Welcome and thank you for joining the second session of Seyfarth's Commercial Litigation Outlook webinar series, Navigating Legal Minefields, Insights on Restrictive Covenants, eDiscovery, and Privacy Compliance. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Rebecca Woods. Rebecca, you may begin.
Thank you so much, Sadie. Hi, I'm Rebecca Woods, and I'm the co-chair of the Commercial Litigation Practice Group. And we're pleased to not only put out our annual forecast of litigation trends, but also to add more value to that forecast by providing these webinar series. This is the second installment, and we're trying a new format, a little bit more of a talk show format, so that you can hear the information in a more conversational and interesting way. And again, as Sadie said, please put your questions in the chat, and I'll do my best to get to them. So, with that, let's start with our restrictive covenant section, and we have Don Mertenite and James Yu joining us. Don is a partner in our Boston office, and James is a partner in our New York office. So Don and James, hello, thank you for joining us. And let's jump right in and talk about restrictive covenants. So they've been much in the news, and we know that there's a lot of attacks on restrictive covenants at both the federal and the state level. Can you talk, Don, a little bit about what's going on the federal level?
Sure. So as you mentioned, we have seen a lot of movement in this area, both at the federal level and at the state level. But starting with the federal level, we have seen some bills in Congress that either seek to ban non-competes or curtail their applicability or enforceability. Frankly, those efforts haven't gone very far, but what we have seen and where we have seen some movement that may become consequential is more on the agency side. So President Biden made it part of his agenda to empower federal agencies, including the FTC and the DOJ, to enact policies that would take aim at non-competes and other restrictive covenants. So the biggest news of the last couple of years was that in January of 2023, the FTC announced a proposed rule that would ban non-competes in all except for two very minor exceptions. And I'm happy to talk about those exceptions. Before I do that, I want to point out that this is currently a proposed rule. We do expect, frankly, any day now, we expect the FTC to issue its final rule, and that may be a little different from what we saw that they pushed out last January as a proposed rule. But the exceptions to the rule, like I said, are very, very narrow. One of the exceptions is if there is a non-compete in a franchise agreement, and the other exception is when there is a non-compete in the context of a sale of a business. But even that exception is extremely narrow. So as it's currently drafted in the proposed rule, the sale of a business exception would only apply for individuals who are selling 25% or more of a business. So the classic example that I always use to illustrate why some attorneys are concerned about this and businesses are concerned about this is because imagine a family-owned business where you have 5 siblings. They each own the company equally, so they each have 20%. And if they sell their family business for $1 billion, none of them have 25% interest in the business that's being sold. So under the current proposed rule, none of them could be bound by a non-compete. So that was one area that we saw a lot of businesses and attorneys who practice in this area a lot raise some concerns. The other really important thing to note about this proposed rule is that it would effectively be retroactive. So the proposed rule states that once it goes into effect, businesses need to alert their employees who are currently bound by non-competes that those non-competes are no longer enforceable. So even if something went into effect last year, an employee in a state that enforces non-competes an employee signed an agreement, it's enforceable, it's supported by consideration, it's narrow enough. Under the FTC's proposed rule, the business would have to let that employee know that the non-compete is no longer enforceable. The other
So Dawn,
thing
let me just jump in real quick. Is the FTC,
Yep.
is this proposed rule applicable to every non-compete in the country, federal and state?
Yes, and not
Wow.
just non-compete. It also, the proposed rule also points out that there are other forms of restrictive covenants that could be considered a de facto non-compete. And they specifically mention non-disclosure agreements. Now, non-disclosure agreements are, everyone for so long thought, well, of course you can have an NDA. Of course, confidentiality obligations won't be impacted by this. But what the FTC is highlighting is that if they have their way, not only non-solicits, but also NDAs that are considered too broad and effectively a non-compete, those could be under attack as well.
Wow. Okay. And so when that rule drops, we don't know what it'll say precisely. When will it go into effect?
So most likely it will go into effect 180 days after the date that the FTC announces what the final rule will be. That said, I have my doubts that this rule will ever go into effect because it will immediately be met by legal challenges. I can tell you at least the U.S. Chamber of Commerce has vowed to challenge the applicability and the enforceability of any such rule. And there are a number of lines of attacks for that. But I suspect that what will happen is there will be an immediate lawsuit challenging the final rule, and it will eventually make its way up to the Supreme Court. This Supreme Court in particular, the makeup of this Supreme Court, they are not big fans of the administrative state. And I strongly suspect that they will determine that the FTC doesn't have the authority to implement policies in this area, just as we saw a couple of years ago in the West Virginia versus EPA Supreme Court case that they said to the EPA, you don't have the authority to essentially legislate in this area.
If I just want to add to that, Dawn, just in addition to your comments, I agree, first of all, with your position on that. And then secondly, in terms of the U.S. Chamber of Commerce, right now the rule is being proposed and it was submitted publicly for circulation to receive comment from, the legal community, academics, think tanks, including the U.S. Chamber of Commerce. And about a year or so after Biden's executive order on non-competes came out, they issued comments pushing back hard on the general notion that non-competes, are stifle the economy, or that they reduce workforce mobility. And obviously there is a time and place where non-competes are essential to protecting legitimate business interests. And I think that's going to be a common theme that's going to come across a lot of the comments that were made in response to the FTC's proposed rule. So ultimately, we do expect, I think, when the proposed rule comes out, it's probably going to be pared down from a complete ban.
And I'll also, just to add to that, James, some people, and I probably am in this camp as well, some people think that the FTC also knows that perhaps their authority in this area is a little shaky, because we'll discuss later some of the state proposals. The FTC has sent letters to governors in those states urging them to sign bills banning non-competes. And so some folks think, if the FTC thought they were on solid ground, why would they need to be encouraging the state legislatures and governors if they just know that everything is going to be banned? So that remains to be seen, though.
Well, that should be fascinating. Any day now, I'm sure you guys will push out an alert with what the FTC has done. Let's switch and talk about the NLRB, because I understand that they are also getting in on the party of anti-non-competes.
Yeah, so the NLRB, also last year in May, the general counsel of the NLRB issued a memo in which she opined that non-competes are usually overbroad and violate workers' rights under the National Labor Relations Act in all but extreme circumstances. Now, what I found interesting about this memo was it doesn't explain what the extreme circumstances would be that might actually permit a non-compete to be enforced. So that remains to be seen. But one thing that is important to note about that memo is it doesn't have precedential effect. It's the general counsel's position. It was sent to regional directors and the like, but those individuals in the NLRB who are looking at these agreements aren't required to find that they are overbroad. And in fact, there was relatively recently a request made by one of the NLRB's regions to the agency's division of advice asking for input on a particular non-compete. And that division of advice issued a memo saying that the non-compete that they were looking at, that they were asked to opine on, was not a violation of workers' rights under the NLRA.
Yeah, just sorry,
go ahead, James.
No, I was going to say, I think the NLRB's principal concern, as I understand it, is, they are basically taking aim at really egregious type of restrictions that are imposed upon, the lower wage employees. We always use the example of burger flippers or janitors, where, that are potentially subject to agreements where they don't really have, much of a position to negotiate these types of agreements. And those are the type of workforce restrictions I think that the NLRB is primarily concerned about.
Okay. All right. Well, I guess we'll see how that evolves under their leadership. Okay. Any other mischief going on the federal level, or does that cover the waterfront?
I think that mostly covers it.
Okay. All right, let's switch to the states where we know there's a lot of activity going on. And let's talk about California first, because California, lots going on there. James, tell us what California is up to now. I mean, I know their non-competes, they've banned non-competes for about 100 years. So you would think they'd be done, but it sounds like they're doing even more.
No, yep. Obviously California is always at the forefront of these issues. They continue to push the envelope. In 2017, the California legislature passed a law, Section 925, which made it incredibly difficult to use out-of-state choice of law provisions for a California employee. And they've been pushing harder on that with the passage of a new non-compete law that went into effect this year. What that law basically provides is that a non-compete is unenforceable regardless of where the employee was working or where he was or she was when she signed the agreement. So you could potentially have somebody who lived and worked in Florida, executed a non-compete agreement in Florida, and then suddenly moves to California. And the California court could potentially say, based upon the new statute, look, I don't care that you were working and living in Florida at the time you signed this. I don't care that you worked in Florida for the past 5 years. You are now a California resident, and we're not going to enforce this agreement that you signed under Florida law. And I don't care what Florida law says. That's essentially what the new statute says. It's obviously went into effect in 2024, so we don't exactly know yet or have any actual case authority to basically fine for that or support that position. And we suspect it's going to be challenged on constitutionality grounds, but that's presently, the interpretation of the law, and it would arguably include not just non-competes, but also customer and client non-solicitations, as well as employee non-solicitations as well.
And just to add to the confusion here, as is often the case in these matters, it's a race to the courthouse to find the best location, especially if you have a California employee or an employee that's in another jurisdiction that is a little bit strict on non-competes. And so, if the employer is able to quickly bring a case in Florida, let's say we'll stick with that example, I have my doubts that a Florida judge is going to credit the California law and say, oh, this person left Florida, so this non-compete that otherwise would have been perfectly enforceable, it just goes up in smoke because they moved to California a day ago. But we're really going to have to see how that plays out in litigation.
So just to be clear about this California law, if I execute a non-compete with an employee in Florida and that employment contract says it is governed by Florida law, and that employee moves to California, California would take the position under its new law that that non-compete is no longer enforceable to that with respect to that employee because they live within the confines of California.
That's correct. Yeah. I guess like it doesn't make a whole lot of sense from a non-California perspective, but you know look, we've seen some of the activity in terms of some arguments that have been being made in support of the new California statute, and some of the arguments are being made include you know, well, now that this person resides in California, is paying taxes in California, is subject to you know, the California law, he or she should also be afforded the protections that are allowed under California law as well. And that's sort of some of the business justifications that we've been seeing in some of the arguments and briefing that have come across about the new statute.
Well, if I were in the business community, I might argue that Delaware should then start enforcing all of its legal provisions on Delaware incorporated companies, no matter where they are. But in any event,
Delaware's not exactly a safe space either, but we'll get to that later.
I know, we'll get to that. Actually, let's go ahead and talk about Delaware. What's going on in Delaware on non-competes?
So surprisingly, over the last couple of years, we've seen some recent cases come across at the Delaware Chancery Court that have taken a fairly hostile stance against non-competes, which seemed to counter traditional you know, Delaware law, where parties are free to contract, you know, as well as protecting business interests. But, you know, there was a string of cases that came out recently, like I said, at the Delaware Chancery level, one of which called the Kodiak Buildings case was invalidated a restrictive covenant that was included in non-compete and non-solicitation that was entered in connection with the sale of a business. In that case, the seller company took the position, obviously, that the buyer should be subject to a 30-month non-compete post-closing. In that situation, though, the buyer complained that the non-compete was overbroad because it wasn't just limited to protecting the assets that had been purchased by the buyer, but it included the buyer's entire geographic footprint. So anything outside of what was the seller's original footprint should, according to the selling company, be fair game. And so the Delaware court agreed with the seller, basically found that the non-compete was overbroad to that extent, but surprisingly refused to pencil it at all and just invalidated the entire covenant. And then in a follow-up case, there was another follow-up case, the Cantor Fitzgerald case, which also came out in 2022. Actually, it was early 2023, I apologize, where the Chancery Court again invalidated a forfeiture for competition clause. In that situation, it was a clause that involved the partners of Cantor Fitzgerald basically would be subject to restricted covenants so long as they would receive benefits contingent upon their compliance with certain restrictive covenants, and they could choose to forego those financial benefits if they wanted to compete. And the Chancery Court found that that was should be viewed under the traditional lens of, you know, whether or not a restrictive covenant is reasonable, and they found that it was an unreasonable restraint on trade and anti-competitive. It was challenged at the Delaware Supreme Court, and the Delaware Supreme Court just recently actually reversed the lower court's decision. So we're seeing some sort of, you know, obviously differences of opinion in Delaware, but it's, you know, the takeaway here is I think Delaware is not really exactly a safe space to be enforcing these restrictive covenants.
Well, although it also sounds so fact specific, and if you're overreaching, and I'm sure at the end you'll talk about the best practices, but, you know, along the lines of bad facts make bad law, it sounds like you're going to overreach. You're going to help create a bad body of law in these various jurisdictions. So something to be aware of in terms of drafting those. All right, so let's talk about some other states. What's going on in, so I understand, I have to say I was very surprised to learn that in addition to California, the 3 other states that have banned non-competes are Minnesota, okay, but North Dakota and Oklahoma. I found that interesting that those were the other banned states. But what's going on in other states?
James, do you want me to take this, or you want to?
Yeah, you want to start with this? So Dawn actually recently blogged about Maine. You want to talk about Maine real quick?
Sure. Well, let me start first. Oklahoma and North Dakota, believe it or not, their bans aren't as old as California, but those have been on the books for quite some time. But as you mentioned, Rebecca, Minnesota now is in that illustrious company. Last July, they banned almost all non-competes in employment agreements. That affects agreements on or after July 1st, 2023. It's not retroactive. But the legislature has figured out that a lot of companies use other choice of law provisions to try to get around these laws in various states. So the Minnesota statute also says that for a Minnesota-based employee, you can't use another state's law to try to get around the ban. New York and Maine, both in the past year, have made similar attempts to ban non-competes. So I'll mention Maine because that's the most recent one. The legislature in Maine recently passed a law that would ban almost all non-competes for workers in the state. Now, Governor Mills just vetoed the bill, and interestingly enough, in her remarks when she vetoed it, she pointed out that the FTC is working in this area, so she thought it was best for the legislature to sit back and see what happens with the FTC first. The legislature did vote to, or they tried to override the veto, but they didn't have the votes, and so they were unsuccessful. So as it stands, there's no ban in Maine. Interestingly enough, a lot of these states that have been making moves are pretty active states. So Maine, for example, I can't remember whether it was 2018 or 2019, but not terribly long ago, Maine passed a law that is on the books today limiting non-competes for certain workers. So we see this in Maine. We saw it in Oregon. Oregon had something like 4 different versions of their law in the span of 6 years. So some of these states, when they pass a law, that's not the end of it. And then James, since you're in New York, why don't you talk a little bit about the New York bill?
And right before I get to that, I just want to add, in addition to what you just said, that there's already close to a dozen states right now that have recently passed legislation just in the past 5 years that have already limited non-competes to a certain extent. Massachusetts, Illinois, Washington, D.C., Colorado, they've all imposed restrictions that are generally focused around income thresholds. Primarily, and so, it's a fluctuating number for a lot of these states, so it changes, year to year, but essentially, the general consensus is like, if you're making under 6 figures at these states, the non-competes are generally not applicable. And then if you're over a certain income threshold, ranging from like $115,000 to $150,000, depending on what state you're in, that's when non-competes might be applicable, subject to a rule of reasonableness test. So what we're seeing in a lot of other states right now is some proposed legislation that have been aimed at curtailing non-competes based upon some sort of income threshold, so that, again, to protect the lower wage non-exempt employees, as opposed to C-suite executives who obviously might have access to trade secrets, and there's more of a legitimate business justification to want to restrain their mobility going to competitors. So New York, just to segue from that, they originally last summer, the legislature passed a complete non-compete ban that was in some facets more draconian than California, because it didn't even include a sale of business exception. It was a complete ban, so it didn't have any income threshold. And it also took aim at non-solicits that could potentially be viewed as a de facto non-compete. So despite passing the legislature, there was, and Hochul had already stated in her State of the State address the year prior that she was in favor of looking at some sort of non-compete ban. There was, the expectation was that something would pass, that she would generally approve either probably not the bill as it was presented to her, but something as some sort of compromise along some sort of income threshold. And that was based upon public comments that she had made that she would be willing to consider a non-compete ban as long as it included an income threshold. And the number that she had floated around was $250,000. And so In light of that, there was some pushback from her office when the bill was presented at the end of last year, because it didn't include some of these exceptions that she was concerned about. And there was, I think, some sort of compromise proposed at that point about possibly floating a $400,000 income exception, but in the end, she just vetoed the bill. And so right now, it's there's no activity being, as far as we're aware, but obviously, I think the New York legislature is probably going to continue putting forth efforts to try to put something in front of her potentially later this year.
Well, I mean, it seems like there are times when non-competes have been used for, people flipping hamburgers, and that frankly just seems silly. But it sounds also like this income threshold seems arbitrary and a deeply imperfect tool itself. So going along the theme of how do you make this work, given the hostility of non-competes, should employers even try to insert those in their employment agreements?
So we've had a lot of clients ask us this: is it even worth it? And you can still use a non-compete in most states, but it's much more difficult now to do it the right way. And this just underscores the need to hire counsel who is familiar with the state laws, because even just in the last 25 minutes, we've talked about a variety of different laws, and that's just what's happened in the last year, right? I mean, each state has different rules and requirements. I think it's important to have non-competes where they're enforceable, because in my view, non-competes are the best way to prevent trade secret misappropriation. Trade secrets are often the most critical assets of a business, and once they're out the door, they're out the door. It's very, very hard and expensive to remedy that and to rectify that conduct. You could file a trade secret misappropriation lawsuit, but again, that sort of litigation is extremely expensive and time consuming. So the best way to prevent your trade secrets from going to a competitor is if you can implement an enforceable but reasonably limited non-compete. But again, that requires knowing of the various laws, drafting an agreement appropriately so that you're not going so broad that even in states that would otherwise reform an overbroad agreement, the court says, you just went way too far. I'm not going to reward you by limiting it. You're just out of luck entirely.
Yeah.
I mean, has the Chamber of Commerce come up with a proposed a limitation on non-competes that businesses find palatable, so there can be some sort of compromise?
Do you want to take it, James, or do you want?
Yeah, I was going to say, so the U.S. Chamber of Commerce, believes that, as a lot of state laws that were non-competes are still enforceable, that there is or there can be a business justification for non-competes, in particular when it's necessary to protect trade secret information. And by and large, access to trade secrets is afforded primarily to higher income earners, not the burger flippers that we had talked about. And that's where I think if you can make the case where a non-compete is genuinely necessary, for example, in a lot of states, obviously, even in states that have banned non-competes, it's deemed necessary in the sale of business context. But going beyond that, C-suite executives, sales executives, higher earners generally tend to have the keys to the kingdom, so to speak. And those are the people, I think, where you will continually see a business justification or business need to impose some sort of limited restriction that doesn't necessarily prevent them from earning a livelihood, although these people are already, generally speaking, probably making sufficient amounts of money. But beyond that, that actually, prevents the misuse of trade secrets. And I think that's the target where a well-drafted non-compete should look at. You have to take a very surgical approach to making sure, to defining what a competitor is and defining what it is that they can or can't do when they after they leave. So, for example, it can't just say, they can't go work for a competitor without, providing any sort of definition. Otherwise somebody who works at, say, Apple can't, works on their phones, can't go work for Samsung washing machines. I mean, it just doesn't make any sense in that context, right? So if you have a very narrow surgical definition of what a competitor is, and then say for a certain limited period of time that they can't do certain activities that's directly related to what they were doing at their prior employer, I think those are the type of covenants that will continuously be upheld in states where non-competes will still continue to be recognized.
And just to add briefly to that, one of the other things that we are seeing more often in some of the state legislation is, James mentioned the wage thresholds. That's a big thing now, but also a right to counsel provision. So if you can show this employee had the opportunity to consult with an attorney of their choice and figure out if this is going to, hurt their ability to earn a living after they leave, I think a lot of states are looking at that and saying that should be part of a reasonable non-compete. So there are things like that, whether it's a wage threshold, right to counsel, whether there's a provision that said in a state law that says you can't use an out-of-state choice of law to avoid the protections of Minnesota, let's say. That's the sort of thing that we're seeing as states start to look at what is reasonable and enforceable.
So it looks like we're at time, but any quick final thoughts on best practices for non-competes for the benefit of our listeners?
Yeah, the reality is, look, we continue to see a lot of evolution at the state court level. And I think, in terms of best practices, companies, particularly, ones that operate nationally or internationally, should continue to stay on top of, changes in state law. That's the unfortunate reality. I think there should be an annual review every year of every company should undertake of their employment agreements to make sure that they're compliant in all the states where they do business. And, obviously, in situations like California, which also included, a notice requirement, to the extent that there are changes that require affirmative action from companies, they need to stay on top of that.
Yeah, and I would just add, as we were just discussing, businesses need to be careful that they're not imposing restrictions that are so broader than the business really needs, because that's when you're either going to have someone like the NLRB or a state judge saying you went way too far and I'm not going to reward you, so I'm throwing out the baby with the bathwater. So that's why it's really important to draft something that's reasonably limited and still provides you protection.
Right. Okay, great. Well, thank you both very much. I appreciate it. And now we're going to pivot from protecting trade secrets to protecting privacy. So we'll pull onto the stage our colleague and partner, Jason Priebe. He is a partner in our Chicago office. Hi, Jason. Welcome.
Thank you.
Why don't you start by talking about what significant developments we've seen in the privacy space this year?
Well, privacy has always been certainly an up-and-comer and a hot topic for compliance. Most recently, I think the most recent trends that have gotten a lot of people's attention from boardrooms on down are this continued rise in regulatory enforcement as well as litigation by private plaintiffs for violations of various state regulations and privacy rights, both some of these state, what we call omnibus privacy laws that just grant privacy rights to a broad category of personal information for a person, as well as some more creative theories of recovery based upon website activity using even state wiretapping or eavesdropping laws that have been on the books for a long time. There's also, just because of some of the increase of these state laws that have taken into effect, that I'm going to talk about in a little bit, that are either in effect now or coming soon, there's increased consumer awareness about privacy rights that they may have or may believe they have, depending on where they live, which also sort of feeds media attention. And then also it's feeding additional states to sort of try to one-up one another with respect to the privacy laws and regulations that they're passing based upon current developments. So, for instance, the Washington My Health, My Data Act was in some large part passed as a reaction to some other state laws that restricted or at least potentially criminalized reproductive rights, women trying to exercise their reproductive rights in various states or jurisdictions. So I think the combination of the new laws, creative and plaintiffs, attorneys, and claims, as well as higher stakes, have all sort of created this perfect storm of risk for compliance for privacy in the past year.
Well, I mean, I have to tell you that when I've talked to my spouse about needing new luggage, and then suddenly all of my social media is filled with luggage, and I'm stalked all over the internet by luggage, I'm a little creeped out, and I would like my privacy rights to be more protected on that front. Speaking of protection, we just spoke with the trade secrets folks, and it's clear there's an unfortunate permanent patchwork of trade secret laws unless the FTC gets its way. Where are we on federal legislation that would make everybody's lives easier on the privacy front?
Yeah, that's a question that comes up every year. And in past years, I have said, even if there were draft laws out there, it's just not going to happen, because based upon what I was reading in the tea leaves about the legislative lobbying and the business interest groups that were opposed to it for various reasons, whether it's marketing or financial or banking, insurance institutions, others. But interesting question, because now there's actually a little bit more of a wellspring of effort in that, and we actually do have some draft legislation out. So that is definitely a stay tuned moment, and I would say that the spark has a bit more oxygen now than it has in the past. And one of the biggest reasons is because of the fact that right now we have maybe 18 or 19 states that have sort of passed their own different variety of what we call omnibus privacy laws. But each one is different, so it has become quite an exercise for a nationwide company to figure out what their compliance footprint is in each of these jurisdictions, because some might have a limit, like your company has to make more than $25 million to qualify. Others don't have that. Some would say you have to process personal information for more than 30,000 residents of the state or 50,000 residents of the state. But some, like Texas, which is coming in July, don't put any restrictions. If you process personal information for any Texas resident, you are subject to their law, as long as you don't qualify as a small business. So just because it has become such a patchwork quilt, and different rights are being attached to different consumers, and that different definitions are even coming through of what is a consumer and who's covered, I think the clamor and the cry is getting louder for some kind of federal legislation that sort of sets all this straight and at least establish sort of a baseline for them.
I mean, if Texas has a broad privacy right, you would think that that is evidence of a fairly broad spectrum of bipartisan agreement, that we need privacy protections of some sort. And then you add into that business interests that probably would like some ease of administration. So it seemed to be doable.
Yes, I couldn't agree more, as well as some consensus on what is personal information and what is this type of information or activities that ought to be at least restrained or controlled. And I think that's where it's going to come. And you mentioned websites and internet activity. That is certainly a hot spot right now, especially what we call web beacons or pixels that will track your activities from one site to another and lead to what they call targeted ads, or cross-contextual behavioral advertising is a fancy term of art for it. But it is what the businesses in the business would say is giving you the most relevant advertisement that's directed towards your interests, but others might see it as something that's happening in the background on their web browser without their knowledge. That, as you mentioned, for some people feels a bit more of a violation of their individual privacy when they browse the internet or do searches or other things.
Mm-hmm. So whenever I go to a website and up pops the, do you want to accept the cookies and what level of cookies do you want? That pop-up does not, when I make my choice, that doesn't reach to these beacons or these pixels. Is that right?
It's an interesting question. And so sometimes yes, sometimes no. And that's another sort of area or battleground, if you will, for some of these laws and even the regulations that are coming out for interpretation of the laws in places like California. And that is, should there be some kind of requirement that people respect your settings from one site to another? So if you essentially have a universal do not track or you register, that everybody has to respect that. Of course, the interesting thing there is if you do that, that's a cookie in itself. A cookie saying, don't give me cookies. But
I would
it's
take
for the
that
right
cookie.
reasons. Right. That's
By the
right.
way, those do you accept cookies pop-ups, that's thanks to GDPR, right?
Yes, that's actually where it started. And that is something else that has evolved in the past year, which is, I know we're talking domestic US, but absolutely the EU issued additional regulations and guidance about cookies, which have changed. So now instead of just saying accept or not, we have these options that started in Europe for only the functional cookies or what's required to make the website, or reject everything or accept everything. So this sort of menu choice. Now, there are people who complain that it's gotten too complicated and that consumers don't understand what they're signing up for or not. But you're correct. That idea, that concept is passing back into these US states in the form of their regulations of their privacy laws. So for places like California, what's coming are going to be more strict controls and regulations about that. And it's something else. I mean, we were talking about the FTC earlier. That's something else that's also coming into the radar screen of federal regulators with respect to commerce and truth in advertising and things like that.
So a lot of the theme of our forecast was AI, Gen AI in particular. How does AI play in its increasing use play into privacy considerations?
It's certainly AI is a hot topic, but and the way that AI has always registered in privacy is with respect to what they call automated decision making, which is restricted in various aspects, certainly in the workplace or employee selection process for like in the state of New York, on a much larger scale in Europe under GDPR. But it's any kind of machine automated decision making that's based upon personal information or individual characteristics, are have requirements depending on the jurisdiction that they be disclosed, or maybe that that you obtain consent, or in some circumstances that you actually give people the ability to opt out and to have some alternative process. So I think we're going to see a lot more about AI with kind of in the context of automated, you know, shall we say, classification or filtering or scoring of individuals for a variety of reasons, whether they be a good customer, whether they be a good hire. Uh, it's always an exception. It's been around a long time in credit worthiness, and that's accepted from all these privacy laws. But people are getting quite creative about AI, and in terms of predicting orders and marketing, as we were talking about before. And that's got a lot of people on edge as well. So I'd look for more regulation in that respect in the future.
Interesting.
But
Okay.
remember that these laws tackle the collection of personal information. So, and the purpose for which it's used. So it's in some respects, it's already there.
Okay. What are some of the things that companies should be thinking about in terms of mitigating their risk of liability on the privacy-related claims?
Well, we've already talked about kind of knowing where you are and what you're doing, and I think that's the most important thing. So know your jurisdictions for your business. That is, what are you doing? What states are you doing it in? And then, just as importantly, what are you collecting, and are you processing, sharing, selling, or doing other things with identifiable information for consumers? Because that's going to determine your footprint for compliance. And in my experience, being a former in-house attorney myself, I think there's a lot of times where the law department is not fully aware of what maybe the marketing department is doing or what they have in mind. So, that's an important thing I always mention to my clients. Have a conversation, keep that dialogue going, because it's a lot easier to at least do things in a more deliberate way with an eye towards compliance than finding out something later after the fact if you get a complaint that
Right.
the information is being collected and processed in violation of one of these laws.
And final thoughts, any misconceptions you would like to disabuse of folks managing companies' privacy interests?
Well, I mean, overall, I think one of the most common misconceptions is that privacy compliances can be fixed easily with a website updated website notice or policy change. Just put some words on the web page and we're good. Even those cookie notices are great, but you have to actually build the mechanisms behind the scenes for compliance. So there's more to it than that. And privacy compliance requires constant attention. It's not a one and done situation. I was just talking about these states that are changing, things are coming into effect now. I haven't talked about the Washington My Health, My Data Act, but that's an entirely different breed of privacy law that governs health related information. So suddenly a company that's collecting nutrition or fitness or even wellness information and drawing decisions about consumers, suddenly they're covered by this law that has health in the name that maybe they weren't even thinking about. So keep your ear to the ground about what's out there and what's coming, and make sure that you, as I said, that you manage that risk. Another sort of final thing that's out there is a specter sort of I do a lot of work in M&A evaluations. Sometimes companies will sell or acquire businesses without looking at what the privacy compliance minefields, to follow our theme, might be. So that's something to also pay attention to, is make sure you know what's out there and what's around the corner for a company you may be buying. Because suddenly, if they're selling you, for instance, all their contacts or customer lists, and you're valuing that, but then you realize after the fact that you can't use it because it was collected in violation of privacy laws, that could be a big ugly
surprise.
discovery. Yes.
Very good. Well, thank you so much, Jason. Really appreciate your talking to us about privacy. I'm going to take a quick, not commercial break to talk about our CLE code. So we have a new process. You can scan this QR code. If for some reason it's not working, then you can write down the CLE code, which is SS2821. And again, that is SS2821. And we can circulate a link to the code in the coming days. So this is your code. I'll say it one more time because no more, SS2821. So there you go on the code. And now we're going to bring onto the stage, we'll move on to eDiscovery. We have our colleague, Matt Kristoff, who is a partner in the Chicago office, and he is going to talk about eDiscovery issues. So Matt, welcome. Thank you for being here.
Thanks so much.
As a litigator, I have to tell you that discovery is ridiculous. And it is the biggest pain point for every client who gets stuck in litigation. And I remember when eDiscovery began to be a thing, I don't know, like 15 years ago, and everybody was promising it would take care of the pain of discovery. And instead, we now have insane costs, in part because the proliferation of email and other electronic data. But then we have ingestion fees, and then we have hosting fees, and it's just very doggone expensive. So can you talk to us about what eDiscovery developers and vendors are doing, particularly the promise of Gen AI? What do we have coming at us that might be less pain-inducing?
Sure, no, and I definitely agree with those pain points. eDiscovery lawyers and vendors, when we have new tools that we can use to analyze or slice data, we get excited because, like you said, data volumes are just increasing. They are, when I started, it was about 3 gigs of email was a huge case, and now we're dealing with terabytes of data, and we don't anticipate that those volumes are going down. So, these Gen AI tools have a variety of different ways that they can help us slice the data. One of the primary ways to do so is through a document summarization. And so loading these large sets of documents in, we're able to generate quick and concise sets of data that are that will allow us to kind of pinpoint what is actually relevant to the document. How is this responsive? It's going to allow us to get to the most impressive data first, and then also circulate that amongst the team. Frequently we have large review teams either contract attorneys or internal teams, and that can make it a little bit difficult to kind of synthesize the information across the document populations we're dealing with. Some of these summaries can also be very effective when you want to do a secondary review. You may be able to slice the data after a first level review occurs, and you can focus pass to your partners or to your secondary reviewers, certain aspects of those documents that they may find more important that they want to focus on. It can also be used for a variety of features kind of after you've made your productions. When you're preparing for depositions, you may take a set of documents, use those summaries to really plan your outlines or to plan different questions that you think might be helpful during those depositions. You can also feed in the transcripts that you've used during depositions and use these large language models to synthesize questions you might use at trial or at subsequent depositions. It's very effective in ways that you can do that. One of the other ways that we think it's going to be used significantly is in privilege log generation. After you finish the significant costs of reviewing documents for responsiveness and privilege, there's always that priv log that's floating out there that you have to, try to scramble to get done because you may have withheld certain documents. One of the concerns that you'll have to be on the lookout for is that Gen AI is great at generating content, but you got to validate it. You have to look at it. For privilege log, while it may be able to speed this process up, you don't want to disclose too much information regarding those documents. You want to make sure that you're providing what you need to under your discovery obligations, the federal rules, and the other local rules. So you'll want to tweak that. You'll want to, maybe it's a great jumping off point, another tool to have in your kit to streamline that process. And finally, one of the ways that I've used Gen AI particularly is in search term generation. Based on receiving discovery requests, it'll allow you to kind of jumpstart that process by feeding in a request and asking the Gen AI tools, what are some other ways that we can get at this data? That can help for that negotiation so that you're not starting with kind of a blank slate. One of the other ways that outside of summarization is the document identification and retrieval methods. And that is kind of more what you would expect in some of the kind of easy button promises that we've seen from vendors, which include, this is going to identify all of the responsive documents in your population. It's going to identify all the privilege docs, and it's going to take the human out of the review. Now we're not there yet, but there's it is a concern, but we're getting there. And these tools are rapidly evolving to the point where things that we didn't think were possible 6 months ago now are. And so, feeding in an RFP and identifying, the types of queries or the prompts that you think would get to responsive information, these platforms are easily able to identify that, generate kind of a various scores or whether or not they think the document is responsive. And most critically, many of these platforms will give you a citation to why do I think it's responsive? Well, it's this portion of the document. And so it can really help to speed up the review process in general. And so finally, kind of the holy grail of this will be to the real-time narrative querying, being able to go back and forth with a review platform and kind of iteratively query the entire universe of your document population. Now, we're not there. Many different vendors are exploring different options. Most platforms currently are kind of using a static model. They've built out their large language model that allows them to query a document population, and they may not be able to take into account the documents that you've loaded in. It's not using the lexicon or the information that is in maybe your client's data. Now, there's some vendors that are trying to figure out a way to do that so that the queries are more appropriately tied to the data that you have actually processed that's relevant to the case. But again, there's some significant costs that are making that challenging for some vendors.
I've done a couple of test runs on some of these programs, and I am waiting for the holy grail when my client sends me, I don't know, a terabyte of emails, and I just want to treat it like it's ChatGPT-4 or any of its competitors and just do queries. Give me a timeline of the contract negotiations. Tell me who the key players were, what happened, this, then, and another time. It absolutely has to be doable, but I don't think we're quite there yet. And when we get there, because I think you and I agree we will get there, probably sooner than we think, how much is it going to cost? Are we going to be Lucy? Well, I guess it would be Charlie Brown with the football. Lucy was holding the football, where we're promised that, all these things will be streamlined and fast, and yet, now we're looking at costs. So what are your predictions on that front?
Right. They will be substantial to start. Many of the vendors that are demoing these, the kind of pricing disclosures are under wraps, but we know that it's probably going to be on a per doc basis as you query them. And when you kind of provide your different queries, it's going to be, you're going to be charged on a per doc amount. And so if you have 1 million documents, you have 10 million documents, this could be a huge, huge amount that you could be hit with. And so there's going to be a lot of planning, not only with the vendors, but also with your team to really fine tune exactly what you're looking for, because you really want to do these kind of submissions, at least initially, under the current models that are built, as infrequently as possible. You want to kind of have your detail, but iteratively running this is something that is not currently going to be feasible. It's similar to Lexis and Westlaw, kind of that first year associate that just kind of runs loose, doing a bunch of research, and you result in a $20,000 bill that you were not expecting. We're trying to avoid those, and so putting some guardrails in place where getting that clarification from your vendors. When am I going to get a charge, and how much is it going to be if I run it across this set? And I think that's really going to help avoid any of those kind of unexpected charges.
Okay, it sounds unsatisfying and bureaucratic to me, but
unfortunately, yes.
We'll see. Any particular considerations for clients to the extent that we would be employing Gen AI in eDiscovery?
Yeah, there's that should be a discussion that you have with the client, because most of these vendors have closed systems. Information is not being transferred outside of a platform. It's not being used to train the platform. And so most clients are okay with that. But there's a few things that that you should consider, is to have a policy in place that not only the clients can use to their employees, how to kind of appropriately use Gen AI. Don't just be going to ChatGPT and dropping in a bunch of client data. There's those privacy concerns that Jason touched on. We see articles about it all the time. And so, not only having kind of guidance for your clients and for your employees, but also, there's some things you can do if you have kind of internet traffic monitoring. Maybe you want to toss in some thoughts about, common Gen AI platforms to see if anyone is, actively visiting those, particularly those that may be dealing with sensitive information or highly confidential data. You might want to get those notifications to find out what's going on.
Right. Okay. And we're near the end of our time, but any hints or recommendations for what lawyers in 2024 should be doing as these tools are becoming more common?
Yeah, I think that prompt engineering which is how you're writing your queries, how you're talking to these Gen AI platforms, is going to be huge. I haven't seen any particular certifications that are kind of have some meat on the bone there, but I think that some of those courses, certifications will be critical for not only your project managers and litigation support, but also for attorneys moving forward.
Great. I was just told, so our firm has Copilot, and I was just told that an effective means of prompt engineering includes thanking it and telling it whether it did a good job or not. And I found that just a level of surreality of, okay, let's bring in Skynet, and it can tell me if it's disappointed in me or not. But
you just want to be on the good side of the AI platforms.
I do. Well, thank you so much, Matt. I really appreciate it. And for all of you who attended, thank you so much for attending our second installment of our Commercial Litigation Outlook webinar series. This one was Navigating Legal Minefields, Insights on Restrictive Covenants, eDiscovery, and Privacy Compliance. We learned a lot from our speakers, and we appreciate your time. So thank you and have a lovely day.